There you go.
Can you hear me all right now?
Yes, we can, sir.
All right. This is Dane County versus YASHEIA Jackson, 26F018. Can I have appearances, please?
Cameron Davies, for the people of Dane County, I appear in person. The defendant appears via Zoom in custody without counsel.
And we have Ms. Jackson, is that correct?
Yes, it is.
All right. The state has decided to charge your case as an ordinance violation instead of as a criminal violation. That's like a ticket. I expect there will be an offer to resolve your case today. What that means is whether you decide to resolve today or not, you will unconditionally be released from custody for this case. However, if you have other cases, they could affect your release. And is there an offer to resolve today?
The county would resolve for court costs.
Okay. So you have an absolute right to plead not guilty, and we can set this case for further proceedings. Otherwise, you can enter a no contest or guilty plea, and you'd be fined $114.50. Payment of that amount can be arranged through the clerk of courts, and you have 60 days to pay it. Would you like to resolve your case today?
Yes, I'll plead guilty.
Okay, then I'll accept your guilty plea. I'll adjudicate you guilty, and I'll enter a fine in the amount of $114.50. And with that, we are adjourned. Thank you.
Do I get out?
Yep, you'll get out.
Next up is TIASIA WILHELMI. Sorry. Okay.
Ma'am, do you say your first name, TIASIA?
Yeah.
Okay. This is the state of Wisconsin versus TIASIA WILHELMI, 25 CM 2979. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
TIASIA WILHELMI appears by attorney William Rakestraw. Ms. WILHELMI is eligible for public defender representation. We are in receipt of the complaint, waive the formal reading, and enter a plea of not guilty.
All right. So you have the right to have an attorney represent you in a case like this. You're eligible for a public defender, so they'll work on getting somebody appointed for you. And Attorney Rakestraw, did he say Ms. Wilhelmi's address is correct on the complaint?
That's
Moraine View Drive?
No, that's wrong.
Okay.
what's your current address?
1329 Glacier Hill Drive.
1329 Glacier Hill Drive, Unit 23. Oh, Unit 3. What city? Okay, Madison, Wisconsin.
And what's the zip code?
53703.
All right, we'll get that updated in our system then. I find probable cause in the complaint. What are the state's recommendations?
One moment, Your Honor.
I guess I can note
Yeah.
there was a PSA filed. The PSA lists that says a 3 out of 6 on the new criminal activity, a 4 out of 6 on the failure to appear, recommends cash bail and pretrial supervision. And what are the state's recommendations?
I will ask for minimum cash bail, I'll say around $500. I'll ask for the sole non-monetary condition that the defendant have no contact with Ronnie E, spelled RONNIE. In support of that, I would note this is an Act 3 offense. I would also note that it was committed based on my timing. It took took place at least about 3 days before the defendant completed the deferred prosecution program. Likely for procedural reasons. They weren't kicked out of the DPU program, as that was sort of referred up, but I think that it constitutes a pretty serious act committed with an open case. So I think some amount of cash bail is appropriate, and I would ask the court to go along with the PSA.
All right, Attorney Rakestraw.
Yes, Your Honor. I'm going to ask that you grant a signature bond on this matter and go against the pretrial service or the pretrial services, pretrial assessment. The reason why is I understand that she was on a deferred prosecution, but it appears she had been out of trouble for over a year while doing that. she has a Rock County case, but that's unrelated. It's not of violent nature. I understand the seriousness of this, of these allegations, but it is a misdemeanor. She has been appearing for our for her DPU, program. So I believe a signature bond will be appropriate here, Your Honor,
Right.
due to the nature of the crime.
And the state's no contact condition was with Ronnie E.
Yes,
E is in Edward.
that is correct.
All right. And any response from the state?
No, Your Honor.
All right. I'm going to order a signature bond with the condition that you have no contact with Ronnie E. Signature bonds come with standard conditions as well. There's two I'll highlight for you. One is follow the law. So if you pick up any new charges while you're on bond, the state could file a charge called bail jumping in addition to the law violation. The other is that you'll show up for court when court is scheduled. So make sure you're checking your mail and showing up for court whenever you have court, all right? Bail can escalate too. It can also be decreased with no contact to be removed, but you're kind of starting at the lightest touch we have. So make sure you're doing what you're doing so that somebody in my position doesn't impose a high level of cash on you, okay? That could result in you sitting. So now's your chance, okay? All right. I will enter a not guilty plea on your behalf.
Oh, Your Honor, I apologize. I know the court has already made the record, but just for the sake of covering bases, I completely forgot. The victim wanted me to read a statement.
Okay.
And I want to make sure I do that before we go off the record.
Yes, please.
I will read verbatim. The victim in this case would hope the defendant could be held without bail or high cash. They let us know the defendant has history of this behavior, assaulting and robbing people and then bragging about it on social media. This incident happened in front of the victim's small children. The victim believes defendant is a danger to the public and thus far continues to get away with this bad behavior with little consequence.
All right. Any response?
Your Honor, I'd stick with my same argument for a signature bond.
I'll maintain my order. And I'll just clarify, no contact means no contact in person, electronically, through social media. If you're posting stuff about the victim, that could be considered contact, and it could also open you up to exposure for additional charges, okay? So just take your space. Don't talk about them. Don't talk about this unless you're talking with your attorney. I'm not going to make that part of my order, but that's just best practices for you, all right? Very good. And with that, we are adjourned.
Good luck.
All right, Ms. Mahoney. Right this way, man. Next up is ELENA WASHICTA. The DNO, we're gonna have a victim on live stream or anything.
I believe there was somebody who had showed up previously, but
For this case.
Yeah.
Go ahead. Elena. This time. The longest system is just.
this is the state of Wisconsin versus ELENA WASHICTA, 26 CM 24. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
ELENA WASHICTA appears by attorney William Rakestraw. I do not have information about whether Ms. WASHICTA is eligible for public defender representation, so she'll need to reach out to our office. We are in receipt of the complaint. Waive the reading, enter pleas of not guilty.
How about the address?
Yes,
Address is good.
yes.
All right. So you have the right to have an attorney represent you on a case like this. Your eligibility for a public defender hasn't been determined yet, so you should reach out to them. If you'd like to have them represent you, they'll do an evaluation to see if you qualify for services, and they'll be able to answer questions about getting somebody to represent you, okay?
Acerca de cómo usted puede conseguir un abogado aquí en este número de teléfono, esta dirección. Okay.
I find probable cause of the complaint. What are the state's recommendations?
Before I give my recommendation, the victim here wished for their wishes to be read into the record. Those being that the victim supports a signature bond and is asking for contact to be allowed with no acts or threats of violence. The state will be recommending a signature bond. However, I will be asking for a no contact with Jose M. R. While I understand the victim's wishes and taking a look, I believe, if I am not incorrect, this is the defendant's first case involving this victim that I was able to see. I don't think a no acts or threats would be unreasonable. However, I think it's worth noting that just this morning at an out of custody case, the victim in this case had an initial appearance that is in case 25 CM 2962 and was given the condition to not have any contact, direct or indirect, with ELENA S.S., that being the defendant. I think for the sake of consistency, a no contact would be appropriate here as well.
I pulled up that case and I can see that that condition is there.
One moment, Your Honor.
So I pulled up that case. I can see that that case condition exists. Attorney Rakestraw?
Your Honor, I have no objection to a signature bond. I would ask for no violent contact, not a no contact. I understand that he has one. But it's my understanding they live together, they reside together, they've been together over a year. I understand the conflicting charges, but in case that gets lifted or separate, I think it's best. I think it would be great for my client if she does not have that no contact order. Considering she has no history. Considering she has no history.
Any response from the state?
No, Your Honor.
I'm going to order a signature bond with the conditions or condition that you have no contact with Jose M.R. I like when conditions match. I think it makes things simpler for people. Although I certainly understand your perspective on that. I'll enter not guilty pleas on your behalf. And we are adjourned. Thank you.
Next up is George Bauer, hearing by Zoom.
Do not be around this.
No, this is not considered.
You know, answer the phone.
No, it's not that.
And not text them.
No, text, yeah.
Okay.
Okay, this one. I didn't hear the name of the next one, was that?
Bauer, George Bauer.
With Bauer. I think there may be one more for the interpreter. Possible. One. He may have changed his brain. So. And we're going to worry about, I assume. He's gonna. See, I think they're really. But it'll take a little bit, no problem. Right? Yeah. Send to branch two. On the, they're adding to the. Send up. It does either.
This is the state of Wisconsin versus George Bauer III, 26 CF 15. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
George Bauer appears by attorney William Rakestraw. Mr. Bauer is not eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, no one. That's it.
And do you know if the address on Bauman Avenue is good?
That is the address we were given as well, so.
And Mr. Bauer, we have a mailing address for you on Bauman Avenue. Is that a good spot for you to receive your mail?
Bowman Avenue? Yes, Your Honor.
Okay, we'll leave that address in our system then. You're not eligible for a public defender. If you'd like an attorney to represent you, one way you can do that outside of the public defender is to take the finding that you're not eligible for a public defender to the Dane County Clerk of Courts, or reach out to them somehow. And you might be eligible to have the county pay for some of the cost of having an attorney represent you, all right? But you should get working on an attorney to assist you if that's what you want sooner rather than later, okay? I find probable cause in the complaint. What are the state's recommendations?
The state is recommending a signature bond. I would ask for the sole non-monetary condition that the defendant have no contact with Officer Truman, except in his official capacity as a law enforcement officer.
Is that TRUMAN?
Like the president.
Okay. And Attorney Rakestraw.
No objection.
Okay. Then I'll order a signature bond with the conditions or condition that you have no contact with Officer Truman except in their official capacity as a police officer. In regards to time limits for the preliminary hearing.
Since the signature bond, I would say we can waive those.
Okay, we'll waive the time limits for the preliminary hearing then, and we are adjourned. Thank you.
Next up is Nicole Pellegrin for.
This is Dane County versus Nicole Pellegrin, 26 FO 20. Can I have appearances, please?
Cameron Davies for the people of Dane County. The defendant appears in person, in custody, without counsel.
All right. So the state has decided to charge your case as an ordinance violation, like a speeding ticket, instead of as a criminal violation. I expect there will be an offer to resolve your case today. What that means is whether you decide to resolve today or not, you'll be unconditionally released from custody for this case. However, if you have other cases, they could affect your release. And you've been charged with a county disorderly conduct ticket. Is there an offer to resolve?
The county would resolve for court costs.
So you have an absolute right to plead not guilty, and we can set this case for further proceedings. Otherwise, you can enter a no contest or guilty plea, and you'd be fined $114.50. Payment of that amount can be arranged through the clerk of courts, and you would have 60 days to pay. Would you like to resolve today?
Yes, please.
And what plea would you like to enter?
No.
Okay, then I'll accept your guilty plea. I'll adjudicate you guilty. I'll enter a fine in the amount of $114.50, and we are adjourned.
Thank you very much.
Thanks.
Right this way. Next up is Abiel Howard.
This is the state of Wisconsin versus ABL Howard, 26 CF 19. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Oh. Okay, and 26 CM 13. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Abiel Howard appears by attorney William Rakestraw. Mr. Howard is not eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal of both criminal complaints, waive the formal readings, enter pleas of not guilty to the misdemeanors. Is this your correct address?
Yeah.
That the address on the complaint is correct, of 2833 Oregon Road.
Sorry, you said Mr. Howard is eligible?
He's not.
Not eligible.
So. Well, yeah.
Fly back to us again, okay?
So you're not eligible for a public defender.
Yeah.
If your situation changes, you can reach out to them and ask them to reevaluate you. Otherwise, you could take the finding that you're not eligible to the Dane County Clerk of Courts and ask for them to cover some of the costs for your representation. They'll conduct an evaluation to see if you qualify for that as well. That's a process you should start sooner rather than later because it can take some time to get a defense attorney.
Yes, sir.
I'm just looking through the complaints right now.
I know. So, okay, I'm free. Before you. Not right.
I am also here to the victim to say something as well.
Yeah, I'm just reading the complaint right now, so just hold on a second, please. Thank you.
Okay. Thank you.
I find probable cause in the complaint. It's my understanding there's somebody who identifies as a victim who would like to make a statement. Can that person please unmute and identify themselves? Use your initials, first name and last initial, or something else.
JEANNE Hill, JH.
Okay, and can you, okay, JH, what would you like me to know?
I was just wanting you guys to know that I would like to have contacts. I share 2 kids with the defendant, a 6-month-old and a 1-year-old, and that's the only person that helps me as far as babysitting when I have to work. I had to miss work this previous weekend because of the defendant being incarcerated. So my bail conditions, I was just wanting no acts of violence and no alcohol as well.
Okay, thank you. What are the state's recommendations?
I will start with the CF matter. In 26 CF 13, the state will be asking for $2,000 cash bail. I will ask for non-monetary conditions that the defendant have no contact with JEANNE H. I would ask that he not possess or consume any alcohol, that he be banned from the 1300 block of Sunfield Street in Sun Prairie. Sunfield is one word. And I would ask that if the defendant is able to post, he report to Dane County Pretrial Services for remote alcohol and GPS monitoring. In the misdemeanor case 26 CM 13, I would ask for $750 cash bail. I would ask for non-monetary conditions that the defendant again have no contact with JEANNE H, and then he not possess or consume any alcohol. I guess for the sake of consistency, I will also ask for pretrial services for remote alcohol monitoring there as well. In terms of support for that cash bail, I'll note the violent nature of the offense here. Obviously, specifically looking at that felony case, it's extremely serious conduct. It's an Act 3 offense, at least the top line is. Multiple counts there are. The defendant also has a significant amount of exposure given the domestic abuse repeater enhancer. I'll also note that at least one of those convictions that counts towards the repeater, that's out of case 24 CM 2202 in Dane County. That was a domestic abuse case initially charged out as battery, criminal damage to property in DC. The defendant ultimately pled to the criminal damage to property. That also involved the same victim as in these two cases. I also think most concerningly is the fact that the much more serious matter, 26 CF 13, was committed after the defendant had bailed out of jail in case 26 CM 13. So obviously he wasn't subject to conditions of bond at that time, but nonetheless had been arrested for and bailed out of jail for a domestic incident involving this same victim, and then went home and committed a much more serious Act 3 offense during that period of time, leading to these two cases having the same initial appearance date today. I understand the victim's wishes. I am sympathetic to issues with childcare, but I think given that fact specifically, that the defendant was able to get out of custody, get an order in date on the CM case, and instead chose to go home and engage in this extremely violent conduct, necessitates, a no contact order at this time.
And Attorney Rakestraw?
Yes, Your Honor. On both cases, I'm going to ask for a signature bond. The reasons why is that Mr. Howard has very strong ties to the community. He's lived here essentially his entire life. His entire family is here. His 4 children live here. He is employed at U.S. Auto Force, where he's worked for 3 years. And as stated by the alleged victim in this matter, she would like him to be able to take care of his kids and things of that nature. That would be virtually impossible to do with a no contact order. I do believe the strong ties community shows that he'll come to court. His prior record consists of 2 misdemeanors, Your Honor. I understand the seriousness of these allegations. I'm not trying to minimize those. However, with his minimal criminal record and apparent appearance to all of his court dates, I believe a signature bond is appropriate here. I would ask that you follow the victim's wishes for contact, but I leave that up to the court, obviously.
All right, any response from the state?
Not at this time, Your Honor.
All right. So there's a few things I have to balance here. There's a victim who's says she wants contact. There's assertion that Mr. Howard has strong ties to the community. He's employed, he has kids. And I have to balance that out against the allegations here that there was a case with the same victim, that the more serious case is alleged to happen after Mr. Howard bailed out. On balance, the state's recommendation is eminently reasonable. I understand this may cause some hardship for JH. However, there's a hardship on children seeing this type of conduct. It can seriously affect their development. There's also substance abuse allegations here, or maybe not allegations, but as a motivating factor for the alleged behavior. So in 26 CF 13, I'm going to order $2,000 cash, that Mr. Howard have no contact with JEANNE H, that he not consume or possess any alcohol, that he's banned from the 1300 block of Sunfield Street, and that 26 CF 19. Oh, yep, 26 CF 19. Thank you. And I'll order that Mr. Howard is only to be released when pretrial services is open so that he can be immediately connected with their services. In 26 CM 13, I'll order $750 cash, conditions that he have no contact with JEANNE H, that he not consume or possess any alcohol, and that pretrial services be in place to conduct alcohol monitoring, and that he's only to be released at a time when pretrial services is open so he can be immediately connected with their services.
Commissioner, I'm sorry, in both cases, is it just alcohol monitoring? I think you got that for on the felony. So I'm not sure why the address ban is only asked for cases.
I'm only going to order that they conduct alcohol monitoring. I can understand why we might want GPS, but I'm not going to order it in this case. I think it's a little too excessive. But it's something that could be ordered in the future. I'll enter not guilty pleas on 26 CM 13 to the charges there. I'll enter not guilty pleas, or I'm sorry, they're all felonies. Will the time limits in 26 CF 19 be kept or waived?
We're gonna keep time limits.
Okay, we'll keep the time limits in place in that case then. And with that, we are adjourned. Thank you. Thank you.
Go ahead.
Great, we were like 50-yard line all the way up, like almost back to the wall, but yeah, no, they were great. Where were you guys?
We were at we're at the south. Oh, downtown. Oh, what was going on? So, like, yeah, one of the guys. Oh, it's their change. So whatever. Yeah.
Next up is.
Right there for the-
Cadena, right?
Sorry, what was that?
Manuel, Cadena, ERAZO. Yeah, so, no, so.
Manuel, Cadena, ERAZO, appearing by Zoom.
All good? This is the state of Wisconsin versus Manuel Cadena ERAZO 26 CF 21. Can I have appearances, please?
Cameron
Este
Davies.
es el caso del estado de Wisconsin contra Manuel Cadena ERAZO 26 CF 21.
Cameron Davies for the state of Wisconsin.
Cameron Davis de parte del estado de Wisconsin.
Manuel Cadena ERAZO appears by attorney William Rakestraw.
Manuel Cadena ERAZO compareciendo por el abogado William Rakestraw.
I have no information about whether he's eligible or not, so he'll have to reach out to our office.
No tengo información alguna para determinar si él es elegible para los servicios de nuestra oficina. Va a tener que contactar las oficinas del defensor público.
We are in receipt of the criminal complaint, waive the formal reading.
Hemos recibido una copia de la denuncia criminal. Renunciemos que se lea.
Sorry if I missed it. Did you say the address was good?
¿Dijo usted si la
That I
dirección
do
era la
not-
dirección correcta?
That I do not know.
Eso no lo sé yo.
So, Mr. Cadena ERAZO, we have an address for you on Broadway Street. Is that a good mailing address for you?
Señor Cadena ERAZO, tenemos una dirección para usted en la Broadway Street. ¿Es esa la dirección correcta para usted?
116.
¿Usted dijo que sí está bien, sí?
116. Broadway Street.
Sí.
Gracias. Yes, that is the correct address. 116 Broadway Street.
Okay. You have the right to have an attorney represent you in a case like this.
Usted tiene derecho a ser representado por un abogado en un caso como estos.
I believe eligibility was not determined.
Correct.
Pienso que la elegibilidad todavía no se ha determinado.
So you should, if you want to have an attorney represent you, one way you can do that is reaching out to the public defender's office and they'll evaluate you to see if you qualify for their services.
Una de las maneras para conseguir un abogado es comunicarse con las oficinas del defensor público para ver si usted califica para los servicios.
I find probable cause in the complaint. What are these state's recommendations?
Determino que hay motivo fundado en la denuncia criminal. ¿Cuáles son las recomendaciones del Estado?
The state is recommending $20,000 cash bail.
El Estado está recomendando $20,000 de fianza.
The state is recommending that the defendant have no contact with the individual listed as child victim.
El Estado está recomendando que no haya ningún contacto con la víctima indicada como menor número 1.
For the sake of expediency and for court records, that individual has the initials YG.
Para que sea expediente y para las actas de la corte, esta víctima tiene iniciales YG.
The state is also requesting that the defendant have no contact with any member of child victim's family.
El Estado también está exigiendo que no haya ningún contacto con la familia de la víctima.
State is further requesting that the defendant have no unsupervised contact with anyone under the age of 18.
También el Estado está pidiendo que no tenga el acusado contacto que no sea supervisado con personas menores de 18 años.
That the defendant be banned from the 100 block of West Broadway Street in Stoughton.
Que el acusado sea prohibido de estar en la cuadra 100 oeste de la Broadway en Stoughton.
And that the defendant be banned from the 100 block of Seminole Drive in Edgerton.
Y que también sea prohibido estar en la cuadra 100 de la Seminole Drive en Edgerton.
In terms of support for that cash bail request, the state would first note the severe consequences for charges such as this, both in exposure as well as social stigma, quite frankly.
Sobre los fundamentos para la fianza de caución, el Estado quisiera primero indicar la gravedad de ser condenado por estos tipos de cargos y también por la estigmación social.
The state would further note concerns about ties to the area. I would note for the court that the defendant is from Ecuador. The state is unsure of his ties to the state of Wisconsin. It appears the only thing that we could come up with is that the defendant has been dating the victim's mother for about 7 months now, which is a very short period of time to have obvious connections to the state of Wisconsin.
Estamos inseguros sobre los lazos que el acusado tiene con esta comunidad. Parece que él es ciudadano del país de Ecuador. Así que no estamos seguros sobre los lazos que el acusado tiene con el estado de Wisconsin en este momento. Lo único que sabemos es que él estaba saliendo con la madre de la víctima por los últimos 7 meses, que es un tiempo bien breve.
That's all I have, Your Honor.
Esto es lo único que tengo, su señoría.
Thank you.
Gracias.
Attorney Rakestraw?
Yes, Your Honor. Your Honor, I have no objections to the conditions of bail that the state asked for. I understand with these charges why those would be appropriate at this time. If a judge chooses to change them later, obviously that is an option.
Entonces, yo no tengo ninguna oposiciones a las condiciones de fianza en este momento. Debido a la naturaleza de los cargos, entiendo que esas condiciones son apropiadas. Y un juez siempre los puede modificar en un tiempo futuro.
As to the cash bail request from the state, I am objecting to that, as I do believe that is excessive.
Pero con respeto a la fianza de caución, opino que es excesivo y por eso me opongo a esa cantidad.
These are only allegations, albeit serious ones, but they are only allegations. And outside of these allegations, there's no other history of this type of behavior from Mr. CADENA ERAZO.
Esta es el primer alegato. No hay ninguna historia de parte del señor CADENA de antecedentes penales.
However, I do understand based off these allegations why cash bail is appropriate in this matter. But I believe cash bail in the amount of $2,000 is more appropriate.
Pero entiendo que, dado la naturaleza de los cargos, sí es necesario tener una fianza de caución. Lo único que opino es que la cantidad de $20,000 es excesiva.
And that has to do with the lack of any criminal record that I can find for Mr. Cadena ERAZO.
Y eso es porque el señor no tiene antecedentes penales.
Any response from the state?
¿Algo para responder de parte del Estado?
No, Your Honor.
No, su señoría.
Well, the conduct alleged is certainly concerning to this court.
El comportamiento alegado es algo de gran preocupación para la Corte.
The lack of ties to the community is concerning.
La falta de lazos con la comunidad es algo preocupante.
I do think $20,000 is bordering on excessive.
Pero pienso que la cantidad de $20,000 es medio excesivo,
But only due to the lack of history,
I'm sorry,
but only due to the lack of
pero
history.
solamente debido a la falta de antecedentes.
I'm going to order $18,000 cash,
Voy a hacer una orden de $18,000 de dinero en efectivo.
no contact with YG,
Ningún contacto con YG,
no contact with YG's family,
ningún contacto con la familia de YG,
no contact with anyone under the age of 18.
ningún contacto con personas menores de 18.
I'll order a ban from the 100 block of West Broadway in Stoughton.
Voy a tener una condición prohibiendo que él esté en la cuadra 100 de la Broadway en Stoughton
And the 100 block of Seminole Drive in Edgerton.
y la cuadra 100 de Seminole Drive en Edgerton.
Each of these charges is a felony. Will the time limits for the preliminary hearing be kept or waived?
Okay. Pardon? Sorry, keep them.
Estos cargos son delitos graves. ¿Se quiere continuar el periodo de tiempo para la audiencia preliminar? Sí, los queremos guardar.
So we'll keep the time limits in place then, and we are adjourned.
Así que se van a mantener los límites de tiempo para celebrar la audiencia preliminar. Estamos en receso.
Thank you.
Gracias.
Next up is Corey Webb. Thank you.
Later. This is the state of Wisconsin versus Corey Webb, 26 CM 27. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Corey Webb appears by attorney William Rakestraw. Mr. Webb is eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, enter a plea of not guilty.
And we don't have an address for Mr. Webb on the criminal complaint. Mr. Webb, is there a spot where you can receive your mail?
Yes, Your Honor.
Okay, and can you provide us with that address, please?
Yeah, would you like it right now?
Yes, please.
615 East Washington Avenue, Madison, Wisconsin, 53703.
All right, we'll get that address in our system then. You have the right to have an attorney represent you on a case like this. You're eligible for a public defender. So they'll work on getting somebody appointed for you. Could be a few weeks, it could be a few months. All right, so just hang in there.
Okay.
Find probable cause in the complaint. What are the state's recommendations?
The state is recommending $750 cash bail, all as for non-monetary conditions that the defendant, or the sole non-monetary condition that the defendant have no contact with Brittany J. Brittany is spelled Brittany. In terms of support for that cash bail request, I will note that the defendant is violating a specific condition of bail, that being no contact. He did that after receiving a $500 cash bail in his open case in which he got no contact with that victim. Clearly $500 wasn't enough. I'll also note that the defendant has a few bench warrants that were issued in the past year. The most egregious being one from January 10th of 2025. That was not served until February 1st of that same year. He then had bench warrants February 27th and June 9th of that year. Both were resolved fairly quickly, but they both were served, not canceled, which leads me to believe that they were not sort of clerical errors. All told, I do think some amount more than the $500 previously posted is appropriate, and I think $750 does the job.
Attorney Rakestraw.
Your Honor, I'm gonna ask for a signature bond on this matter. I understand that Mr. Webb has had some misses, based off of the complaint itself. I believe there are some mental health issues going on here. I have made it clear to Mr. Webb that he is not to contact this individual that's listed in here. I would ask for no, I also believe that the behavior here, which is, he's not, based off the allegation, he's not supposed to do what's here, but this is a matter of him making phone calls where apparently he might have been having a mental health episode based off of the last call that he's alleged to have made, which is to the suicide helpline. I do not believe more incarceration is necessary. He is public defender eligible. It means he's indigent. $750 would basically mean he's being locked up for what appears to be a mental illness. So I do believe a signature bond is appropriate here, based off the conduct that's alleged in the complaint and his history.
Any response from the state?
No, Your Honor.
All right. You know, this could be a mental health episode. It could be something else. That's not something I can determine here, but the allegations are that there's a specific condition of bail that was violated. I think that warrants an increase in cash. I think $750 is a reasonable increase. So I will make that order. I'll also order no contact with Brittany J. I will enter a not guilty plea on your behalf, and we are adjourned. Thank you.
Next up is Russell Miller, appearing by Zoom.
This is the state of Wisconsin versus Russell Miller, 26 CM14. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Russell Miller appears by attorney William Rakestrom. I do not have information regarding Mr. Miller's eligibility, so I cannot speak to that. He will need to reach out to our office in regards to his eligibility. We are in receipt of the criminal complaint, waive the formal reading, enter pleas of not guilty.
Right. And is the address on Easttown Boulevard good, or?
I do not know.
So, Mr. Miller, your eligibility for a public defender hasn't been determined, which means if you'd like a public defender to represent you, you should complete an evaluation with them. And it can take some time for an attorney to get appointed. So I would encourage you to complete that process as soon as possible so that people who are applying faster than you don't jump ahead of you in line, okay? And we have an address for you on Easttown Boulevard. Is that a good mailing address? Or did you say you weren't sure about that?
I do not have any information as to whether that's the correct address or not.
And Mr. Miller, is your address on Easttown Boulevard? Do we have Mr. Miller there?
At the door, he's just laying down and refusing to answer.
Okay, we'll keep that mailing address then in our system. I find probable cause in the complaint. What are the state's recommendations?
The state is recommending $1,000 cash bail. I will request non-monetary conditions that the defendant have no contact with Annalisa C. That is spelled Annalisa, both common spelling, but one word. State would also ask for no contact with any member of Annalisa's family. The state would further ask that the defendant be banned from Davidson Drive in Sun Prairie. It's Davidson with a extra D in there. The state would further ask the defendant not use or possess any dangerous weapons, as that term is defined by statute. And that if the defendant is able to post your report to Dane County Pretrial Services for remote GPS monitoring, terms of support for that cash bail, the defendant was released on bail in his other case here in Dane County on December 23rd of 2025. He committed this offense pretty much a week later. He was given a signature bond there and then commits a new crime pretty swiftly after being released on bail. Looks like the concerns from that case are still pretty relevant to the state, those being the defendant is an Arizona resident. Seems he was coming up here and he was staying in a hotel. He got kicked out after beating up people in the hotel, leading to that previous CM case. That underlying case includes an Act 3 eligible offense. Here, there's also some concerning facts, such as the defendant trying to burn his fingerprints to remove them, allegedly so he could kill his girlfriend and her daughter. There are other threats, including finger guns and things of that nature. I think both the quick turnaround to a new case, the lack of ties to the state, as well as the threats here require some amount of cash bail. I think $1,000 is appropriate.
I just want to clarify the screen name. I think you said Davidson with two D's. I'm looking at the complaint, it looks like it might be Davison with just a single D in it.
It could well be.
It may not make a ton of difference, but a pretrial services or they don't need it.
It does appear that that's a typo in my notes, and it would be Davison, Davison.
You said Annalisa, common spelling for both names, but
Yep,
is that ANNALISA?
that is correct.
Okay. All right. Attorney Rakestraw?
Yes, Your Honor. Your Honor, I have no objection to the no contact order. As that does seem appropriate based off of what's listed in the complaint. I would object to the cash bail request. Looking at the complaint with the timing where he does have the other case where he was released and then this behavior occurred. So I understand why some cash bail is appropriate based off that timing of this. However, I do believe $1,000 is excessive, considering other than these two cases, I see nothing, does not appear as Mr. Miller has any other criminal record that I'm aware of. Even though these allegations are serious, however, they are still misdemeanor charges. And as such, I would ask for cash bail in the amount of $250, Your Honor.
All right. Any response from the state?
No, Your Honor.
All right. Well, there's a few things at play here. There's the new charges. There's clear willingness to not show up to court with the resisting an officer charge and the behavior underlying that charge. There's also allegations that Mr. Miller won't comply with the law if he is released, given what he's alleged to have said about burning his fingerprints off so that he could commit a homicide without being identified. There's the the quick turnaround from the release to the allegations of the new charge being committed. I think $1,000 cash is appropriate. I'll order that. I'll also order that Mr. Miller have no contact with Annalisa C. or her family, that he's banned from Davison Drive in Sun Prairie, that he not use or possess any dangerous weapons. And I'll order GPS and pretrial services to enforce that ban. And I'll order that Mr. Miller is only to be released at a time when pretrial services is open and can receive him, so that he can be connected with that GPS, so that ban can be enforced immediately. I'll enter not guilty pleas on Mr. Miller's behalf, and we are adjourned. Thank you, sir.
Next up is Cesar Ordonez Gonzalez. Ordonez Gonzalez?
Unfortunately, he said he did not get it.
This is the state of Wisconsin versus Cesar Ordonez Gonzalez, 26 CF 18. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Cesar Ordonez Gonzalez appears by attorney William Rakestraw. Mr. Ordonez Gonzalez is eligible for public defender representation. We are in receipt of the criminal complaint and we waive the formal reading. And I don't believe there's any. Yep, just that.
I'm sorry if you said it, was the address for Mr. Ordonez Gonzalez good?
The address we were given by Mr. Ordonez Gonzalez is 6 Prentice PRENTICE Place, Madison, Wisconsin, 53704.
And you said eligibility for a public defender had not been determined?
No, he is eligible.
So you have the right to have an attorney represent you on a case like this. You're eligible for a public defender. They're gonna work on getting somebody appointed to your case, okay? I'm just reviewing the complaint right now. Find probable cause in the complaint. What are the state's recommendations?
The state is recommending $500 cash bail. I'll ask for non-monetary conditions that the defendant first have no contact with Laura D. Laura spelled LARUA. Would also ask the defendant have no contact with Peter D. I'll just note both of those last initials were D as in dog. The state would further ask the defendant not use or possess any dangerous weapons, as that term is defined by statute. In terms of support for that cash bail, it looks at the defendant just recently had an initial appearance for a felon in possession case. He received $400 cash bail there. State believes that a similar amount is appropriate here, as this complaint now outlines that that gun from that case was allegedly stolen. The car the defendant had recently been driving in the other case was also now discovered to have been stolen. Given the added exposure contained in both of these, I believe both of these felony charges, the state does believe that more cash bail is appropriate. Given the cash bail in the underlying case, $500 seems appropriate.
And I'll note that there's a PSA filed on this case. Lists the activity as 5 out of 6 on the new criminal activity, a 4 out of 6 on the failure to appear scale. Recommends modest cash bail and pretrial supervision. Attorney Rakestraw.
Yes, Your Honor. Your Honor, in this matter, I'm going to ask for a signature bond. I understand the assessment asked for modest cash bail. I understand the state's asking for cash bail. I understand that he had received cash bail on case ending 2989. However, I will say, Mr. How long were you on this sentence that you're starting? 18 days. So, 18. No, how long was your sentence for that? But you're on paid. Is that the? Yeah, that's what you're serving. Yeah. Your Honor, he is currently serving a sanction until January 18th. So he is going to be in custody. However, based off what's in this complaint, which are just allegations, Your Honor, I do not believe that cash bail is necessary in this matter. No gun was recovered. I understand there's an allegation that he stole a gun, but they did not recover one, I don't believe, in the complaints. Yes, and that was a firearm that was just, sorry, there was a firearm there. However, they did not find it on Mr. Gonzalez's person. It was in the vehicle. It's my understanding that he has proof that he was given permission to drive that vehicle. Obviously, this is not the place to litigate that, but I do believe he does have proof of that. So with that, Your Honor, I would ask for a signature bond with the understanding that he's already out on cash bail and he's serving a sanction.
All right. Any response from the state?
No, not at this time, Your Honor.
All right. And is the spelling indeed LARUAD of one of the no contacts, or is it LAURA?
It is LAURA. I probably could have guessed that.
And Your Honor, no objection to the no contacts.
Very good. This kind of an interesting case as cash was just set on the 30th, the amount of $400. Really a question of with these additional facts, would additional cash have been warranted? I think it's possible that additional cash would have been warranted had these allegations been a part of the first complaint. I'll give Mr. Ordonez Gonzalez the benefit of the doubt here. I'll order a signature bond with the conditions that you have no contact with Laura D, Peter D, and that you not use or possess any dangerous weapons as that term is defined by statute. Possession of a weapon is more than just holding a gun in your hand. It's having a gun within the area under your control. And it's also the not using or possessing a dangerous weapon includes things designed as a weapon. It also includes things being used to hurt people. So an example I give is if you're, I'm sorry.
The jobs that I do, it's construction, so it's remodeling, so.
Yep, so if you're using a hammer to pound a nail into a wall, that's not a dangerous weapon because it's
Okay.
not being used to hurt somebody. If you're swinging a hammer at somebody's face, then there's a.
I should leave my tools at work. Just to be in the price.
I'm not gonna give you legal advice.
Okay.
I would say if you shouldn't try to hurt people.
That's, I'm not, that's not me.
Okay, very good. So, those will be the conditions that I ordered today. These are both felonies. Will the time limits for the prelims be kept or waived?
We'll waive them.
Okay, we'll waive the time limits for the preliminary hearings then. And with that, we are adjourned.
Thank you. Stay away from this one.
Yeah.
Next up,
Stay away.
oh,
Everybody's still on my wall.
They should be getting.
No. And
Oh, you're gonna need to go. So now that's what you're there.
Okay.
Yep, and not go there without.
Yeah. All right, next.
Atkinson.
This is the state of Wisconsin versus David Atkinson, 26 CF 14. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
David Atkinson appears by attorney William Rakestraw. I do not have information as to whether Mr. Atkinson is eligible for public defender representation. He will need to reach out to our office for that to determine that. We are receipt of the criminal complaint, waive the formal reading, enter pleas of not guilty to any misdemeanors.
Sorry if I missed it. Did you say the address is good?
That I do not have information.
Mr. Atkinson, we have a mailing address for you on Mills Street. Is that still a good spot for you to receive your mail? Okay, I see a thumbs up. So we'll keep that address in our system. Your eligibility for a public defender hasn't been determined yet. If you'd like a public defender to represent you, you should reach out to their office to complete an evaluation. It should be a quick evaluation. And they'll get back to you and let you know whether you qualify for a public defender or if you'll have to seek other sources of representation, okay? Before I get to the state, there was a PSA filed with the court. It lists this as a 6 out of 6 on the new criminal activity scale. It has Mr. Atkinson rated as a 4 out of 6 on the failure to appear scale. Pursuant to the, it's flagged, pursuant to the cash or pursuant to that and the overall evaluation recommends cash and pretrial supervision. What are the state's recommendations?
The state is recommending $500 cash bail. I will ask for the sole non-monetary condition that the defendant be banned from all Kohl's stores. It looks like the defendant had already permanently been banned from Kohl's stores. He acknowledged that to law enforcement, which just shows a disregard for rules that concerns the state. Looks like the defendant doesn't have a great track record of making court dates. I'm seeing a bench warrant issued March 31st of 2021. That's a little dated, but it's worth noting because it wasn't served until a full year later on March 4th of 2022. Bodily only warrant was then issued again only a few weeks later, March 28th of 2022. There was another one January 12th in 2023. And then there's just the fact that the defendant committed this crime only 4 days after being released from an in custody case. That's case 25 CF 2948, so a felony case. And within 1 week was committing a new crime despite being given a signature bond. I think at some point, some amount of cash bail is appropriate given that history and the behavior. I think $500 is appropriate.
Attorney Rakestraw.
Yes, Your Honor. No objection to the non-monetary conditions. As to the bail itself, based on the timing of this, of this alleged incident, based on the time when he received the signature bond previously, I understand why some cash bail would be appropriate. I would say cash bail, the amount of $200. That's based on the nature of the new allegation, which is retail theft, and the nature of the open felony matter, which based off those charges, I imagine are fairly related to what is going on in this behavior.
All right. Any response to the state?
No, Your Honor.
I'm going to agree with the state. The history of the underlying the repeater and the bail jumping give this court great concern. Retail theft isn't the most serious crime on the books, but when somebody's released on bail, there are expectations, and they are agreeing to comply with certain things, and there's allegations that that hasn't happened in this case. So I'll order $500 cash and a ban from all Kohl's store. I'll enter a not guilty plea as to count 1. Count 2 is a felony. Will the time limits for the prelim be kept or waived?
We'll keep them.
Okay, we'll keep the time limits in place for the prelim then, and we are adjourned. Thank you. Hold on.
Next up is Antoine Allgood. Good.
This is the state of Wisconsin versus Antoine Allgood, 26 CM 21. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Antoine Allgood appears by attorney William Rakestraw. Mr. Allgood is eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, enter pleas of not guilty. The address were given by Mr. Allgood is 1819 Aberg Avenue, Madison, Wisconsin, 53704.
You have the right to have an attorney represent you in a case like this. You're eligible for the public defender. They're going to work on getting somebody appointed for you as soon as possible. It's a process that can take a few weeks. It could also take a few months. Just depends on attorney availability. I find probable cause in the complaint. What are the state's recommendations?
The state has no objection to a signature bond. The state would ask for the sole non-monetary condition that the defendant be banned from the UW-Madison Hospital unless brought by an ambulance or by law enforcement for a legitimate emergency.
And Attorney Rakestraw?
No objection.
All right. So I'm going to order a signature bond with the condition that you're banned from UW-Madison Hospital unless you're there for a genuine medical emergency. I think imposing the condition about the ambulance or being brought there by law enforcement could be a strain on resources. So if you're there at UW Hospital to get seen for a legitimate medical emergency, that's fine. But otherwise, you shouldn't be there, okay? Mr. All right. I will enter a not guilty plea on your behalf, and with that, we are adjourned. Thank you.
Good luck, guys. Don't be at the hospital.
Brenda, swing. Next up is Javion Olds for bail bond hearing. Old.
This is the state of Wisconsin versus Javion Olds, 25 CF 1752. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Davion Olds appears by attorney William Rakestraw. Mr. Olds is eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading. The address I have for Mr. Olds is 615 East Washington in Madison. 1 second. Got it. Your Honor, having spoken to Mr. Olds, it's my understanding that he missed court due to what appears to be a lack of communication. He did not have an attorney at the time. He states he did call the court after he noticed that he had missed court, which I believe tracks. He says he was unaware of the date as mail had been returned undelivered for Mr. Olds. And that is why he did not appear for court, Your Honor.
All right. What's the state's position?
I'm going to ask for $500 cash bail. Taking a look at the notes available to me, and I'll quickly try to check CCAP. I'll say $500 is appropriate. It was what the state originally asked for at the defendant's initial appearance. We did so based on the exposure here, 2 felony offenses with repeater enhancers, as well as what is described in my notes as concern about what the defendant's ties to the area are. So that's a concern about the defendant's voluntary appearance in court. He then did miss court. He would have received a notice in hand on September 22nd of 2025. There he had a status conference where he did in fact not have an attorney. He was eligible for an SPD. He would have received notice in hand of his appearance November 17th. On November 17th, it appears he did have an attorney. Mark Leonard appeared at that hearing, though the defendant did not. He then was in the wind for almost 2 months. I think that clearly makes that concern that the state had initially valid. The defendant was given an opportunity on a signature bond. He blew it. I think $500 here is appropriate.
All right. Attorney Rakestraw, any response?
Your Honor, I'm going to ask that you give Mr. Olds one more opportunity on a signature bond. It's my understanding he's lived in Wisconsin his entire life. His dad lives in Green Bay. He is currently has the address on East Washington. It's like it's stated, it's my understanding he did call the court. It appears he was unaware that he had an attorney. I don't know I don't know why his attorney did not reach out to him. But I would ask for one more opportunity. He's either going to show or he's not. If he doesn't show, then obviously there's going to be cash bail. He has strong ties to the state. I don't believe this is a situation where he's going to be running, Your Honor. Yeah.
Well, it looks like my review of the court record comports with that of the state. Looks like an attorney was appointed in October. There was a non-appearance in the middle of November in which Mr. Old's attorney did appear. The signature bond ended up being forfeited. Judgment of that was entered in the middle of December. It looks like, from what I can tell, that Mr. Olds was picked up on new charges, but they were declined. So this isn't a situation where Mr. Olds turned himself in. I believe if I ordered a signature bond, it would again be some time before we were able to secure his appearance, if we even were able to. I think $500 cash is reasonable, given the posture of the case. So I'm going to order $500 cash. And I'm going to order the conditions remain the same, that those being that Mr. Olds not be at any target location, and that he not use or possess any controlled substances or drug paraphernalia without a valid prescription. Time limits were previously waived for the preliminary hearing. With that, I believe that's all I can do for the parties today, so we are adjourned.
His name is Mark Leonard. Hopefully they'll have.
Next up is
You'll get a
William
letter from
Bauer.
us. The Bowens?
Yes.
This is the state of Wisconsin versus William Bowens, 26 CF 22. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
William Bowens appears by Attorney William Rakestraw. Mr. Bowens is not eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, and enter pleas of not guilty to any misdemeanors.
Right. And is the address on
Got it.
Academy Street a good mailing address? Okay.
Yep.
I see Mr. Bowens shaking his head, yes. You're not eligible for a public defender, but you've been provided with information on how to contact the public defender if you feel like it.
I just contact them, hours and write all my information down and find a good one.
Okay, so it sounds like you're familiar with the process. You have the right to have an attorney represent you on a case like this. I find probable cause in the complaint. What are the state's recommendations?
The state has no objection to a signature bond. We would ask for the non-monetary conditions that the defendant first have no contact with Danielle G. That the defendant be banned from the 200 block of South Academy Street in Stoughton. And that the defendant be banned from the 200, and that the defendant not use or possess any dangerous weapons, as that term is defined by statute.
And Attorney Rakestraw?
Your Honor, I have no objection to the signature bond. I would ask that you not impose a no contact order, as this is where the 200 block of South Academy Street is where Mr. Bowens lives. I understand the allegations in the complaint. However, it does appear that the person performing the violent actions was not Mr. Bowens. Mr. Bowens appears to have been going in trying to resolve this matter or trying to prevent this from happening. So I would ask that he not be punished due to the behavior of this other individual. As such, I would ask for no violent contact with the person the state is requesting no contact order with, Your Honor.
All right. Any response from the state?
No, I would just emphasize, I think the facts as contained in the criminal complaint justify the request.
I get it. Fair.
So I'll enter a not guilty plea to count two. I'll order a signature bond with the condition that you make no acts or threats of violence to Danielle G. I'll order that you're banned from the 200 block of South Academy Street in Stoughton, and I'll order that you not use or possess any dangerous weapons. You know, I could order the no contact. It's probably in your best interest to not have contact with Danielle G. But from what I can gather from the complaint, that might be a hardship on you that may not be warranted at this time. Bail conditions are flexible. That is to say, if this isn't working out, there's more allegations or anything like that, state can come back to court and ask for an increase to the no contact, the ban from the address. So please make sure you're doing what you need to do and staying away from people you don't need to be around, and hopefully you can work through this and eventually get it behind you. That's gonna include you following the law while you're on bond, so you don't pick up any bail jumping charges, and that you're showing up for court when court is scheduled, okay?
Yeah.
Very good. In regards to the time limits for count one,
We'll waive those, and Your Honor, just to clarify, so it's no violent contact with the alleged victim, but he is banned from the address.
I'm sorry, it's no acts or threats of violence to Danielle G.
Yep.
I shouldn't have, if I said the ban, I shouldn't have said that, my bad.
Okay.
Thank you for correcting me. Yep, and not to use or possess any dangerous weapons.
Understood.
Very good.
Thanks.
I believe that's all, thank you.
Yep, good.
Next up is Anthony Mitchell for a forfeiture. Yes.
This is Dane County versus Anthony Mitchell, 25 or 26 FO 19. Can I have appearances, please?
Cameron Davies for the state of Wisconsin. The defendant appears in person, in custody, without counsel.
And are you Mr. Mitchell?
Yes, sir.
Good afternoon. So the state has decided to charge your case as an ordinance violation instead of as a criminal violation. Specifically, you're charged with a county obstructing or resisting an officer. I expect there will be an offer to resolve your case today. What that means is whether you decide to resolve your case today or not, you'll be unconditionally released from custody for this case. However, if you have other cases that could affect your release, is there an offer to resolve today?
The county would resolve for court costs.
So you have an absolute right to plead not guilty, and we can set this case for further proceedings. Otherwise, you can enter a no contest or guilty plea, and you'd be fined $114.50. Payment of that amount can be arranged through the clerk of courts, and you would have 60 days to pay. Would you like to resolve your case today? And you don't have an attorney because this is a ticket. Like I said, it's like a speeding ticket.
So just take the ticket.
Well, you could fight it, and I would enter a not guilty plea on your behalf. If you're not sure, I could enter a not guilty plea on your behalf. Usually the state will keep an offer open until the pretrial conference, which would be the next step if you wanted to pursue this case.
So I'll just pay the ticket.
Okay. So you said guilty?
Yeah.
Okay.
140, you said, right?
I'm sorry?
$140.
$114.50?
Yes.
Okay, then I'll accept your guilty plea. I'll adjudicate you guilty. I'll enter a fine in the amount of $114.50. Like I said, you'll have 60 days to pay that. You can work with clerk of courts to get that figured out. And with that, we are adjourned. Thank you.
Next up is ABIEL for forfeiture.
This is Dane County versus Ashraf Abdali, 26 FO16. Can I have appearances, please?
Cameron Davies for the people of Dane County. The defendant appears in person in custody without counsel.
And are you Mr. Abdali?
Yes, sir.
Good afternoon.
Good afternoon, sir.
The state has decided to charge your case as an ordinance violation, like a ticket, instead of as a criminal violation. Specifically, you're being charged with a county disorderly conduct. I expect there will be an offer to resolve your case today. What that means is whether you decide to resolve today or not, you'll be unconditionally released from custody for this case. However, if you have other cases, they could affect your release. Is there an offer to resolve today?
The county would resolve for court costs.
So you have an absolute right to plead not guilty, and we can set this case for further proceedings. Otherwise, you can enter a no contest or guilty plea, and you'd be fined $114.50. Payment of that amount can be arranged through the clerk of courts, and you have 60 days to pay. Would you like to resolve your case today?
Sir, just like I was not given the chance by that time, I was a little bit feeling nauseated, and I felt that maybe if I vomit or something, I'm really sorry to be speaking about that. I wasn't able to speak with the police by that time, so I did not know, like their side of detention was just clear. But from my side, I wasn't able to explain what happened at that occasion.
Okay.
So.
Then I'll enter a not guilty plea on your behalf.
So just like I'm just not, it's my first time being detained, so I don't understand what exactly, if I pay the amount of fine now, so I would be released and.
So you can't be held in custody on a ticket, and the state has decided to charge this case like a ticket instead of like a crime, okay? So it's like a speeding ticket. So
Yes, I would like to just, I don't, if that works, yes, and I would be released
well,
now.
it's up to you. So regardless of how you plead today, you're going to be released, okay? So you can enter a not guilty plea, and we get this set for a pretrial conference. And I give you information about the steps for the trial. Or you can enter a no contest or a guilty plea, and you'd be fined $114.50. And you'd have 60 days to pay that amount.
Okay, that's okay, I will pay, so I will not have to pay in the court next time, so it will be on finished in this if I pay the fine.
Yes.
Okay, yes, sir, so I will go for paying that.
Okay, so I'll enter a no contest plea on your behalf. I'll adjudicate you guilty, and I'll enter a fine in the amount of $114.50.
Sir, just like will this go on my, for in the future, will this appear that I've committed this crime? Because
Well, if you're telling me you did it, then it'll go on like a ticket. It would be a county disorderly conduct.
So just like I'm not sure about one thing that what happened from my side that I was not able to explain to the police that they put me into detention. If I get to know that that was not a problem, maybe I would just go for not being
Okay, then I'll enter a not guilty plea on your behalf.
Okay.
This trial will be to a judge unless the court receives within 10 days of today's hearing written notice of a request for a jury trial and a $36 non-refundable fee.
Okay.
That would be to a 6-person jury, and you don't have a right to an attorney in a case like this. You can retain one, but you would have to pay for it yourself, or you'd have to pay for the attorney yourself.
Okay, sir, the guilty that would be
So I'm
I'll
gonna
go for the
enter a
first.
not guilty plea on your behalf.
No,
because you
no,
said
the
you weren't-
guilty. I'll just.
No,
Okay.
I'm gonna enter a not guilty plea on your
Okay.
behalf because you're telling me you need a little bit more time to think about it.
Oh,
And I'm not
sorry.
gonna go back and forth with you.
I'm sorry,
If
sorry.
you'd like to enter a guilty plea, you can reach out to the to the district attorney's office, and they might be able to connect you with how to resolve the
Okay.
case.
The notice,
Sir.
hearing is going to have instructions on it, it'll have an email address and a phone number the defendant can use to contact the DA's office. If they want
Sir,
to-
I will just request. I'm so sorry, sir. Just please put it so it would be a big headache for me. I'm just on a study period, so I don't want to appear.
Okay, but you,
Yes.
Defendant does looks to be defaulted, probably the amount that the DA just offered.
okay,
Yeah, the 114 you said I will pay.
okay, but you're telling me you didn't do it.
I would say, okay, I've did it. I've did
I'm gonna
it.
enter a not guilty plea on your behalf. We're adjourned.
Okay, thank you, sir. Thank you, sir.
I'm so sorry for taking your back pain.
No, you're not.
Next up is Scott Donohue. Thank you. Are you able to hear okay?
This is the state of Wisconsin versus Scott Donahue, 26 CF 16. Can I have appearances? Oh, so,
I haven't heard of it
Yep.
there, so first on this.
Yep, you're good. You can connect them and then I'll call the case again.
Well, let's just try it. I can hear it when you spoke.
Okay.
Well, you might as well try the assistive device.
Yep, just try the device because we already have it out. All right, this is the state of Wisconsin versus Scott Donahue, 26 CF 16. Can you hear me all right?
Go ahead.
All right, can you hear me all right?
Yeah, go ahead.
Okay, can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Scott Donahue appears by attorney William Rakestrom. Mr. Donahue is not eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, and that's it. Enter pleas of not guilty to any misdemeanors.
All right, and Mr. Donahue, we have a mailing address for you on Church Avenue. Is that still a good spot for you to receive your mail?
Correct.
Okay. We'll leave that address in our system then. You're not eligible for a public defender. If you feel like your circumstances have changed, you can recontact them and they'll be able to re-evaluate you to see if you qualify under your new circumstances. Otherwise, you can take the finding that you're not eligible for a public defender to the clerk of courts and ask them if you're eligible for county representation,
Yep.
for the county to pay for some of the
Correct.
cost of your representation. I find probable cause in the complaint. What are the state's recommendations?
The state is recommending $3,000 cash bail. I'll ask for the sole non-monetary condition that the defendant not operate a motor vehicle. In terms of the request for cash bail, the state would note the fleeing behavior primarily. That indicates someone who's likely unwilling to appear voluntarily in court. There's also the resistive behavior with law enforcement when they arrived on scene. The defendant was also on bail at the time of this offense. So, and if you give me 1 second, I think all things told, given the exposure the defendant now faces, considering he gave his driver's license to the officer on scene before immediately fleeing, I do think that a substantial amount of cash bail is appropriate.
All right, Attorney Rakestraw.
How much you ask for? 3?
3, yes.
Yes, Your Honor. Your Honor, in this matter, I do understand why cash bail is appropriate. However, I do think 3,000 is excessive. I'm going to make a request of cash bail in the amount of $1,000, Your Honor. If you need more, I would say at most $1,500. Mr. Donahue is retired. He is on a fixed income. I understand the seriousness of the allegations, which is why I am asking for cash bail, but I just believe 3,000 is excessive. It's my understanding he has been making his appearances at court. He has his attorney that he has was court appointed, so he obviously doesn't make too much money through his retirement accounts, Your Honor. So yeah, that would be my request.
All right, and I'm sorry, there was I should also mention, there's a PSA filed with the court that recommends a signature bond and pretrial supervision. Any response to the state?
No, Your Honor.
All right. Well, I think I'm in agreement with the state that there needs to be what I think to most people would be a significant amount of cash to ensure that Mr. Donahue appears. Charges alone, I think indicate, the flee elude, the resisting, indicate a unwillingness to comply with the court process. There's also the 2 felony bail jumpings the violating the IID and the operating while revoked that show a willingness to not follow the law or follow the rules that are being set up for Mr. Donahue. Additionally, I believe one of the underlying cases is an OWI fourth, which also has a bail jumping charge on it. That's 25 CF 2248. So I'm going to order $3,000 cash that Mr. Donahue not operate a motor vehicle. I'll enter not guilty pleas to the misdemeanors counts 2, 3, and 6. Regards to the time limits for the preliminary hearing on the felony charges.
Do you want to wait? Want to have you later here immediately? Say it again. Do you think you're gonna be able to bail it? Bail myself. Yeah, do you think you're going to be able to? What do you think you're going to be able to? Yeah, I know, yeah.
We can waive them, Your Honor.
What's the total? 3,000. Yeah.
No, 3,000.
That's at 3.
Oh, okay.
Yeah.
Yep.
We can waive the time limit, Your Honor.
Okay, then we'll waive the time limits for the preliminary hearing then, and we are adjourned. Thank you.
Thank you. Right this way. Okay. Next up is Nevada Maurice.
Like, just got added, it's probably the bottom of the direction.
Thank you.
The newest guy.
So I don't actually have a complaint that I can see. It's not getting pulled up.
I saw that there was a document in there, but I did not verify that it was the complaint. I will print copies for you. Does anybody else see a copy of that complaint?
Nope, I'm good.
Then I'll call the case while that's getting completed. This is the state of Wisconsin versus Nevada Varese, 26 CM 29. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Nevada Varese appears by Attorney William Rakestraw. Mr. Varese is eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, and enter pleas of not guilty to any misdemeanors.
I'm sorry, you said Mr. Varese is eligible?
Yes.
Okay. And we have an address for you on Thurston Lane. Is that your correct mailing address, sir?
Yes, sir.
All right, we'll keep that mailing address in our system then. You have the right to have an attorney represent you on a case like this. You're eligible for a public defender. They're gonna work on getting somebody appointed for you, okay?
They go to the next page.
I'm just reviewing the complaint right now. find probable cause in the complaint. What are the state's recommendations?
The state is recommending $500 cash bail. I will ask for non-monetary conditions that the defendant first have no contact with Trisha H, except via third party for child custody and exchange. I will note on the record that, if you give me 1 second, that the victim also specifically wanted the state to request for phone contact for child purposes and exchange. The state will further ask for non-monetary conditions that the defendant be banned from the 5100 block of Anton Drive and the 4600 block of Thurston Lane. In terms of support for the cash bail request, I would note that the defendant does have prior bench warrants. I'm looking for one from a 2021 case, but it was served interestingly in put out in 2023. I believe that was because of prior bench warrants being issued in that case. But ultimately, he was given a bench warrant March 7th of 2023. He was in warrant status for over 3 months until late June there. Since he has had other bench warrants, I don't think that was putting too much weight on. Most of them were canceled or withdrawn, but they do indicate sort of a inconsistency with coming to court and abiding by court orders in that way. I'll also note that I think some amount of cash bail is warranted here from an Act 3 perspective. We do have an incident here where the defendant battered the victim multiple times over the holiday with children present. She was left with visible bruises and injuries. He acknowledged in a text that, quote, "This is why you end up black and blue." This was all after he had threatened to kill her. So I do think that there are concerns about violence that Act 3 was designed to protect the victim against, and I think some amount of cash bail is appropriate under that analysis as well.
Right. Attorney Rakestraw?
Yes, Your Honor. Mr. Varese has strong ties to the community. He's lived in the Dane County area his entire life. His parents live here. His siblings live here. All of his children live here. One was currently living with him. Your Honor, I have no objection to the non-monetary conditions. I do believe phone contact for the purpose of childcare would be appropriate so that Mr. Varese can help with the children. As to the cash bail, Your Honor, I understand based off the complaint why some cash bail would be appropriate. I believe cash bail in the amount of $250 would be appropriate, Your Honor, and that's due to the nature of the allegations and his history.
All right. And I'll give the state an opportunity to respond, and I'm not sure why any contact with the children is appropriate, given what's been alleged in the complaint.
Yeah, I will defer in terms of what the state is requesting to the charging attorney's decision to just leave the no contact with the victim. But I certainly understand the court's concern.
And Attorney Rakestraw, do you have anything to add on that point?
No, Your Honor. If the victim is requesting help with the kids, I think that's appropriate. And that's limited at just phone contact. I think that's fine.
Yep. I'm going to order $2,000 cash. I'm going to order that Mr. Varese, you have no contact with Trisha H. I'm going to order that you're banned from the 5100 block of Anton Drive and the 3100 block of Thurston Lane. I'm also going to order pretrial services for GPS monitoring to enforce that ban. I'm going to order that you only be released at a time when pretrial services can receive you, so you can be connected with that GPS right away.
I just want to double check the address for the second ban area. I had on Thurston Lane the 4600 block.
Yes.
Oh, okay. 4600. Sorry about that. I'll correct that ban to the 4600 block of Thurston Lane. Mr. Varese, I believe that means you'll need a new mailing address. Is there a different spot where you can receive your mail?
I'm supposed to be paying rent this there, you know what I'm saying, so my kids have to let it go, and for her, you know what I'm saying, so I don't know. You know what I'm saying, I don't have the ability.
You just gotta give them the address and where you
So,
send mail.
But
truthfully, I don't have an address for you.
Okay, well, your attorney said that your parents live around here. Could you possibly
Oh.
receive your mail with your parents?
I don't, well, this is 80. I've,
If you can't remember it now, that's fine. What we can do is leave the address as is, and then if you remember it, because I understand this is a highly stressful situation. If you remember it, you can get that address updated with the court, and then we'll send mail to that address, okay?
if there's any chance we do 1,000.
No. I mean, there's threats to kill, there's, this is occurring over multiple dates, but pretty significant. So I think the state would be rightfully justified in even asking for more.
I'm gonna do follow.
No, no contact. This is a bail condition, bail conditions can be amended, but today that's going to be the order, and until it's amended, that will remain the order. I'm sorry if I missed it, or I'm sorry, I'll enter not guilty pleas to each count. And I believe that's all I can do for the parties today, so we are adjourned. Good, thank you.
Right this way. Next up is Grant and Ryan.
That's the song.
Okay.
Just saying.
What was the name of that one? Sorry.
O'Brien.
Yeah, no, I get it. I get it.
This is the state of Wisconsin versus Grant O'Brien, 26 CM 25. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Grant O'Brien appears by attorney William Rakestraw. It's my understanding that Mr. O'Brien does not want to be represented by SPD outside of this initial appearance. So we will not be appointing anyone. If he so desires to seek out our representation, he will need to apply. We are in receipt of the criminal complaint, waive the formal reading, enter pleas of not guilty to the misdemeanors.
So, Mr. O'Brien, we have a mailing address for you on Chipper Lane. Is that still a good spot for you to receive your mail? I'm sorry?
Yes.
Sure, yes, okay. And you have the right to have an attorney represent you on a case like this. You've got a slip of paper with contact information for the public defender. If you change your mind and you like to have them represent you, just give them a call and they'll conduct an evaluation for you, okay? I find probable cause in the complaint. What are the state's recommendations?
The state is recommending a signature bond. I would ask for non-monetary conditions that the defendant first have no contact with Terra O, Terra spelled Terra. The state would also ask the defendant have no contact with James K, and that the defendant be banned from Chipper Lane in Sun Prairie.
Attorney Rakestraw.
Yes, Your Honor. Your Honor, I have no objection to the monetary or to the signature bond. No objection to that. As to the no contact order, I would ask that you consider no violent contact orders. My understanding, these are Mr. O'Brien's parents. And it is, I believe there's mention from them that he has some mental health issues. So obviously they don't want him there. They don't have to allow him to stay there, but I would like for him to have the ability to go there if his parents wish to allow him to stay at their residence again, Your Honor.
All right, any response from the state?
No, Your Honor.
All right, and I'll note that the 72-hour no contact was enforced by both, I believe, Terra O and James K, according to the complaint. I'll order a signature bond. The conditions that you have no contact with Terra O or James K. I'll also order a ban from Chipper Lane in Sun Prairie. We have that as your mailing address. Is there a different spot you can receive your mail? A friend, the Beacon, Job Center. Okay. We send out notices for court through the mail. So if you get a new mailing address, you should update that with the court. Otherwise, if you have a phone, you can sign up to receive notices for court through text messaging. I'd encourage you to do that as soon as possible so that you know when to show up for court. Because if you miss court, a warrant could go up for your arrest.
Court systems, you guys have way to pick up paper, court.
No, we mail it out. I think you can check on CCAP.
Sorry, you have our phone,
I'm sorry.
no phone.
All right, well, if that changes, you should update that with the court. Otherwise, it's going to be your responsibility to show up for court when court is scheduled, okay? I'll enter not guilty pleas on your behalf. And I was saying before, I think you can check on CCAP to figure out when your court dates are, if you have access to a computer. And with that, we are adjourned. Thank you.
Right this way. Next up is Willie Fields.
This is Dane County versus Willie Fields, 26 FO 17. Can I have appearances, please?
Two cases, and one of them we do need to be on the record for.
Okay. Yep. We're also on the record for 25 CF 2585. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Willie Fields appears by attorney William Rakestraw. Mr. Fields is not eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, and according to my files, that address on Portland Parkway is the correct address.
Okay. So you have the right to have an attorney represent you in a hearing like this. It looks like you're not eligible for a public defender, but if you feel like your circumstances change, you can reach out to them using that piece of paper we just gave you and ask them to reevaluate you. One of those pieces of paper should have contact information for the public defender. It looks like in the CF case, we are here for a bail bond hearing, and on the ticket case, are we expecting that ticket case to just track with the bail? Okay,
I think that makes sense.
very good. It looks like the bail bond is due to a bench warrant that was issued on the 2nd. Looks like Mr. Fields was picked up on Portland Parkway. I'll start with the state. What are your recommendations for bail?
The state will be requesting, I'll ask for $300 cash bail. I will note that the defendant did have, other than this most recent bench warrant, he did have a bench warrant issued December 29th of 2025 for a failure to appear at a status conference on that same date. He had 5 bench warrants issued across 5 cases back in July 26th of 2023. He's facing serious charges here. They're violent charges. I think ultimately, given those factors, some amount of cash bail is appropriate here.
Right. Attorney Rakestraw.
Yeah. Your Honor, I'm going to ask that you issue a signature bond in this matter. Mr. Fields is retired. He's on veterans benefits and retirement. He's on a fixed income. It's my understanding that he stated that he missed court due to not having his phone available to him. His phone had been taken. Your Honor, looking at the record, it appears Mr. Fields has no criminal record. He's had charges in the past, but everything seems to have been dismissed. He's an elderly individual. Jails are not great places for individuals that are elderly. I understand the seriousness of the charges, Your Honor, but with his age and the lack of a criminal record, I would ask for a signature bond, Your Honor. I understand the miss, but I would imagine he relies on other people to get him places, and if he doesn't have his phone, that becomes virtually impossible for him.
All right. Any response from the state?
No, Your Honor.
Don't say anything.
So I see some tickets in the past. I do see this case, it's a felony charge with two misdemeanor charges. It's like the past cases have all been dismissed, as far as I can tell. Oh, that's not. So, Mr. Fields, you know when court is scheduled, you gotta make court, right? Okay, and try to set up, rides or whatever you need to get here beforehand. Don't try to do it last second, okay?
Yes.
Okay, very good. I'll give you another chance. I am concerned that there's another ticket or a ticket alleging disorderly conduct. But you really need to make sure you're showing up for court scheduled, and make sure you're following the law so that you're not picking up any bail jumping charges, okay? Okay, so I won't order the signature bond forfeited. It looks like there was a notice of bail bond forfeiture that went out due to the missed court appearance. I'll reorder the signature bond with the same conditions as before, that you shall not have any contact, direct or indirect, with SLM, and that you shall not consume or possess alcohol, okay? Talk to your attorney, and then I'll wait for you to do that.
She never goes home. You have to go through the eviction process. Or you have to go through the eviction process. You have to go to the courts and say, I want this one. No, she don't live. If she doesn't live there, then you need to call the police and have her escort her. That's what I did, but they never escort her out. So again, that's why I'm always here. You have to talk to the police about that. Well, I do, they don't do nothing. While that's recorded, stay away from. She said, and I'm just telling you, go with the police and have them escort her out of your house. What I did. With the last one, go with the police and then do an eviction process. That's what you have to do. Okay? What time is it? Have to evict her. Did they have the guys escort her out? Go with them, have them go with them. They can have them go with you. The time say, I need your help to get this woman out of my house. That's all you can do. It makes you show up to court.
All good?
Yeah.
All right, then with that, we are adjourned. Thank you.
Next up is Trevor Holt.
Please need a minute. Yeah, I'll take a second.
Thank you.
Yeah.
Next is Trevor Hall. No, that's fine. You guys get up the hallway. Hall. No way.
This is the state of Wisconsin versus Trevor Alt 26 CF 23. Can I have appearances, please?
Are we also addressing 25 CF 2953?
I don't see it on the calendar.
Filed late.
Okay.
If you're in the same spot, I just reordered the calendar so they're next to each other now. We have 25 CF 2953 and 26 CF.
Okay.
Sorry.
Okay, I see it now. All right, we're also on the record for 25 CF 2953. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Trevor Alt appears by Attorney William Rakestraw. Mr. Alt is eligible for public defender representation. We are in receipt of at least one of the criminal complaints. No, I think we have, nope, I have both of them. We waive the formal readings, enter pleas of not guilty.
So you're eligible for a public defender and you have the right to have an attorney represent you in these cases. They'll work on getting somebody appointed for you as soon as possible, but sometimes that's a process that takes a few weeks, sometimes it takes a few months. So just hang in there, okay? We have a mailing address for you on 6th Street. Is that still a good spot for you to receive your mail? Okay, we'll keep that address in our system then.
No problem. Appreciate it. Got it.
Okay. I find probable cause in the complaints. What are the state's recommendations?
In 26 CF 23, the state will request $750 cash bail with the sole non-monetary condition that the defendant be banned from all Fleet Farm locations. Double checking that it is Fleet Farm, not Farm Fleet. And in 25 CF 2953, the state would request $500 cash bail. I would ask there for the sole non-monetary condition that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription. In terms of the purpose of cash bail, the defendant is now on his 5th and 6th open cases in the state of Wisconsin. By my count, case 26 CF 23 involves the defendant lying to law enforcement about his name. He has bench warrants from November 19th of 2025, as well as September 24th of 2025. There's increasing exposure here. Obviously, I believe he is still actively in warrant status out of SHAUK County. Ultimately, when it's two warrants, both those dates I gave, September 24th and November 19th of 2025. Those were both warrants, bench warrants issued out of SHAUK County. Those are still pending as of this date. I think that sheds pretty good light on the fact that he was lying to law enforcement about his name. He continues to rack up cases. He continues to rack up exposure. He doesn't want to come to court. He doesn't want to interact with law enforcement in a way that is productive and get these cases settled. I think really there's no other choice than to keep adding cash bail, and I think the amounts requested by the state are appropriate.
Right. Attorney Rakestraw.
Yes, Your Honor, Mr. Alt does have strong ties to the community, lives with his family, with his parents. However, he does have a serious drug addiction. Obviously, he has the bench warrants out of SHAUK County. So I do understand why cash bail is appropriate here. I would make a recommendation of $500 on each case.
And any response from the state?
No, Your Honor.
The state recommended $750 on 26 CF 23.
That is correct.
Okay. Well, I think that regardless of what I ordered today, there's going to be a hold. There's the SHAUK warrants as well as a Department of Corrections warrant, or I'm sorry, hold, excuse me. I think cash does need to be imposed. I'll do $500 on each case. Which is a little less than what the state recommended in 26 CF 23. I'll order a Fleet Farm ban in 26 CF 23. I'll also order in each case that Mr. Alt not use or possess any controlled substances or drug paraphernalia without a valid prescription. Given the DOC hold, I'm guessing pretrial services as a support to conduct drug monitoring won't be necessary, so I won't order that, but I did consider it. Mr. Alta, if this is an addiction issue and I don't make findings or anything like that, I don't determine guilt or innocence. But if it is, it's something I'd encourage you to start working on sooner rather than later, okay? There are great people who do a lot of great work in this community regarding addiction, but it's going to be something where you're going to have to do the work. They can't do that work for you. I certainly wish you the best of luck, okay? I will enter not guilty pleas as to any misdemeanors. In each case, there are felony charges. Will the time limits be kept or waived?
We will keep them.
They will keep the time limits for the preliminary hearing then. And with that, we are adjourned. Thank you.
Next up is Kyle Hume.
This is the state of Wisconsin versus Kyle Hume, 26 CM 22. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Kyle Hume appears by attorney William Rakestraw. Mr. Hume is eligible for public defender representation. We are in receipt of the criminal complaint. Waive the formal reading, enter pleas of not guilty, and the address on the complaint appears to be correct.
All right. So you have the right to have an attorney represent you in a case like this. You're eligible for a public defender. They're going to work on getting somebody assigned for you, okay? It could take a few weeks. It could take a few months. Just hang in there, all right? I find probable cause in the complaint. What are the state's recommendations?
The state is recommending a signature bond. I would ask for non-monetary conditions that the defendant first have no contact with Nathan H. And second, that the defendant be banned from the UW-Madison campus per the ban map.
And Attorney Rakestraw?
No objection to the signature bond, Your Honor.
Okay. Any objection to the non-standard conditions?
No.
All right. Then I'll order a signature bond with the conditions that you have no contact with Nathan H. and that you're banned from the UW-Madison campus per the ban map.
Who's Nathan H?
I'm sorry?
Who's Nathan H?
I'm sorry?
You said I was partial to that. Oh, okay.
I will enter a not guilty plea on your behalf, and we are adjourned. Thank you.
Right this way. Next up is DAVION Gentry. Gentry.
This is the state of Wisconsin versus Davion Gentry, 26 CF 007. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Davion Gentry appears by attorney William Rakestraw. I do not have on here whether Mr. Gentry is eligible for public defender representation. However, on his prior cases, he is represented by a public defender, so that'll need to be cleared up. We are in receipt of the criminal complaint. That's it. Well, I'll waive the formal reading, sorry.
So you have the right to have an attorney represent you on a case like this. It looks like your eligibility for a public defender hasn't been determined yet. So you'll want to reach out to them if you want them to represent you. and complete an evaluation. If you are eligible, sometimes it can take a few weeks, sometimes it can take a few months for somebody to get appointed. So that's a process you'll want to get started as soon as possible, especially as they catch up from their backlog, okay? I think Attorney Rakestraw, you said the address was good on the complaint?
Yes.
Okay.
Oh, wait, no, I did not.
You still live at 233 Allied Drive?
Yes, that is correct.
Okay. Thank you. I find probable cause in the complaint. What are the state's recommendations?
The state is recommending $5,000 cash bail. I will ask for non-monetary conditions that the defendant have no contact with NICHOLE H, spelled NYASIA. The state would also ask that the court find good cause for admonishments under chapter 940.47. I will note that the defendant is on, I believe, his fifth open case, all involving the same type of behavior against this victim. I'd note that those 940.47 admonishments have been found in every other case. I believe that the defendant is under, at least my notes indicate that. If I'm incorrect on that, I'd be willing to be corrected. He's previously had substantial amounts of cash bail imposed on his cases, upwards of $7,000. He's been able to post $2,000 and continues to engage in behavior that is clearly in flagrant violation of his conditions of bail and puts the victim at risk, puts them at risk of intimidation as well. So I think ultimately there's really no choice but to ask for more cash bail.
All right, Attorney Rakestraw?
Yes, Your Honor. This is gonna sound weird. He already has $9,000 in cash bail set in these matters. I understand this is all tied to the same victim. However, this is not new behavior. This is from October of last year. It appears that the state has been delaying in charging. I don't know why. So I do not believe it's fair to increase cash bail for Mr. Gentry, considering this is prior behavior that the state just failed to charge for some reason. He has a significant amount of cash bail. He has a trial set in his new matters. I would imagine this is maybe going to get tied into that. But with the amount of cash bail he already has, I don't believe new cash bail is necessary, nor do I believe it's appropriate, considering this is not new behavior, Your Honor.
Right. So I'm looking at 25 CF 1231. That has offense dates on April 26, 2025. I'm wondering if I pulled the right. That looks like that's the same victim in this case. So with that April 2025 offense date, this is alleged to have occurred in October 2025. So when you say last year, I'm not, are you saying the delay in charging from October until January of this year?
Yes.
Okay,
He's been in custody for a while,
okay.
from my understanding. That's what I mean. This is not something new that occurred while he was out. This is something that happened in the past. He's been in custody for this $9,000 cash bail for at least a month, it appears.
Okay. I see.
3 months? 2 months?
Okay. I see
So that's what I'm saying. This is it, they just charged this now. I don't know why the delay was there. So I'm just saying, I just don't believe new cash bail is appropriate here.
I see. Any response to the state?
Sure. I would note, just in case the court had any questions about it, it looks like these charges were referred up to our office December 4th. It was formally charged December 10th. Outside of that, I don't have any real reason as to why we're here for the initial appearance January 5th. But I don't think that there was a significant delay in terms of the state issuing these charges. Obviously, there was an investigation here. It's not as simple as a dispatch call to a residence and seeing two people together, or arresting one and referring up charges later that date. Outside of that, I'll wait for further argument.
Right.
And Your Honor, just to be clear, I'm not alleging, I'm not accusing the state of any improper behavior. I'm just like, this is an old incident that why he's been in custody already, so.
Okay. I think I understand the parties' positions and the court record. Yeah, thank you for those clarifications. So I'm looking at the complaint, and there's a piece in here about the bail conditions getting changed to allow contact for the purposes of childcare. That change happened in September of 2025. And then these allegations are alleged to have occurred October of 2025. Anytime somebody's given a chance with, with bail getting modified, and then there's allegations that they haven't taken a positive opportunity with that chance. It strikes me that an increase is then warranted. I do think $5,000 cash is appropriate on balance. So I'll order $5,000 cash, and the condition that Mr. Gentry have no contact with NICHOLE H. There's 4 felony bail jumping charges in this case. I understand he's been sitting. I understand there's a trial set. Perhaps the outcome of the trial will influence a bail modification. But at this point, I do believe that those conditions and that amount is appropriate.
Commissioner, are you making the no contact finding pursuant to 940.47?
Yep, I'll issue the 940.47 warning. So whether you sign bail or not, you're under a no contact order. So I'll find that knowing and malicious prevention or dissuasion of a victim or witness has occurred or is reasonably likely to occur. And I'll order that you have no contact with NICHOLE H pursuant to that 940.47 order. If you violate that, you could be held in contempt of court, whether or not you post bail or bond. And a violation of that 940.47. A violation of that order could include a bail jumping charge. In regards to the time limits for the preliminary hearing for these charges.
Keep them.
Okay, we'll keep the time limits in place then, and with that, we are adjourned. Thank you.
Next up is Quante Carter for a forfeiture.
This is Dane County versus Quante Carter, 26 FO 15. Can I have appearances, please?
Cameron Davies for the people of Dane County. The defendant appears in person, in custody, without counsel.
And are you Mr. Carter? Good afternoon. So the state has decided to charge your case as an ordinance violation instead of as a criminal violation. Specifically, they charge you with county disorderly conduct. I expect there will be an offer to resolve your case today. What that means is whether you decide to resolve today or not, you'll be unconditionally released from custody for this case. However, if you have other cases, they could affect your release. And is there an offer to resolve today?
The county would resolve for court costs.
All right. So what that means is you wouldn't be released today, you'd be held, but it would be only be on the DOC hold. So you have an absolute right to plead not guilty. We can set this case for further proceedings. Otherwise, you can enter a no contest or guilty plea and you'd be fined $114.50. Payment of that amount could be arranged through the clerk of courts and you would have 60 days to pay. Would you like to resolve your case today for that amount? Okay, then I'll enter a not guilty plea on your behalf. The trial will be to a judge unless the court receives within 10 days of today's date written request of a hearing, written request of the hearing to be to a jury. That also requires a $36 non-refundable fee, and that would be a 6-person jury. There's no right to an attorney in a case like this. However, if you want one, you'd be able to pay for one and have an attorney represent you at the hearing. Assuming nothing new comes in, I'm guessing the state will keep this offer open until the pretrial conference, which will be the next step in this case, all right? And with that, we are adjourned. Thank you.
Right, it's fine. Next up is Darrell Banks.
This is the state of Wisconsin versus Darriell Banks Jr., 26 CF 20. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Darrell Banks appears by attorney William Rakestraw. Mr. Banks is eligible for public defender representation. We are received the criminal complaint, waive the formal reading, and that's it.
And Mr. Banks, we have a mailing address for you on Vernon Avenue. Is that still a good spot for you to receive your mail? And what's your correct mailing address?
Or no, 2117 Avenue Street.
Can you say that a little bit louder?
2117 Avenue Street.
Okay. Is there an apartment number?
Number 3.
Okay. And is that in Madison?
Wisconsin.
Stoughton? And do you know the zip code?
52589.
Okay, we'll get that updated in our system then. And find probable cause in the complaint. What are the state's recommendations?
The state is going to be recommending $2,000 cash bail. I will ask for non-monetary conditions that the defendant first have no contact with Davin R, spelled DEVON. That the defendant be banned from all car dealerships. And that the defendant not operate a motor vehicle. In support of that request, I would note the nature of this offense. These are 2 pretty serious felonies, specifically looking at the fleeing charge. I mean, that in and of itself is always concerning, even when we just see the charge itself with regards to how a defendant interacts with law enforcement. Here, the defendant ultimately reached speeds of up to 140 miles an hour, which is just the jaw-dropping speed. It's the type of speed where you're surprised cars don't just fall apart at that speed. He at the time was also on juvenile supervision for operating a motor vehicle without consent. So this is clearly repeated and frankly escalating behavior. Given all that, I do believe that substantial cash bail is appropriate. I think $2,000 does the job.
All right, Attorney Rakestraw.
Your Honor, in this situation, I'm going to make a request of a signature bond. I understand that is difficult, hard to say with these allegations and what's occurred here. But I'm going to say that because Mr. Banks does not have or at least from what I'm seeing, does not have an adult record. He is 17. He is under the age of 18. I understand in this state we treat them as adults. However, I do not believe a 17-year-old is an adult. He spent his entire life in the Dane County area. His family lives here. He lives with his grandfather. It appears his father is in prison, Your Honor. So I'm asking to give Mr. Banks a chance while out on a signature bond due to his age. You going to school? He goes to school at Madison. He attends Madison East High School, Your Honor. So I understand the seriousness of the allegations. I'm not trying to mitigate that, or minimize that, but he is a 17-year-old kid. And so I'm asking you to give him a chance to go back and live with his grandfather while he deals with this.
Any response from the state?
No, Your Honor.
All right, I understand Mr. Banks is 17 years old. There's also really what's motivating my decision is the last paragraph of the complaint in the facts section. It says that Mr. Banks was on juvenile probation and parole He was AWOL for over a year. That's a long time to be AWOL while you're under strongest touch the juvenile system has, apart from being waived into adult court. While being on supervision, I don't think I've ever heard of the state reporting of a car being driven that fast. Those are almost instantaneous death speeds if there's any sort of accident. I care about you too much to let you out on $2,000 cash. I do. This type of behavior is not acceptable at all. It's an allegation at this point. It'll be the state's burden to prove it. But you can't have other people working harder to protect you than you are yourself. I'm going to order $5,000 cash. I'm going to order that you have no contact with, I believe it was DEBON, DEBONR. I'll order that you're banned from all car dealerships. I'll order that you're not to operate a motor vehicle. I will enter a not guilty plea to count 3. As to counts 1 and 2, will the time limits be kept or waived?
Oh, keep them.
Okay, we'll keep the time limits in place then, and we are adjourned. Thank you.
Next up is Murray Allen.
Wait. B is in boy?
No, Devon
Oh.
would be, not sure how to pronounce it, but it's a V.
Okay, I heard totally different. Thank you. I'm sorry. Yeah.
No, yeah, 45.
Thank you.
We can never believe the exception. This is, you know, the reality of the law, we had this about for your day. Voice. I'm going 120. Not here, man. Insane.
This is the state of Wisconsin versus Murray Allen, 26 CF 13. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Murray Allen appears by attorney William Rakestraw. Mr. Allen is eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, enter pleas of not guilty to any misdemeanors.
I'm sorry, I was reading something when you began. You said Mr. Allen is eligible? Is that
Yes,
correct?
correct.
And we have a mailing address for Mr. Allen on Olson Court. Is that a good mailing address?
It appears to be correct, yes.
Okay. We'll keep that address in our system then. You have the right to have an attorney represent you in a case like this. You're eligible for the public defender. They're gonna work on getting somebody appointed for you. Sometimes that's a process that could take a few weeks. Sometimes it can take a few months. So just hang in there, okay? I find probable cause in the complaint. What are the state's recommendations?
The state is recommending $1,000 cash bail. I will ask for non-monetary conditions that the defendant have no contact with the individual listed as child victim 1. Give me a second to verify I'll come back to that, what the initials are.
The probable cause statement has JAB.
That would make sense. Seemed to be mislabeled in my file. I would also ask the defendant be banned from any physical discipline of any child, and that the defendant be banned from all Dick's Sporting Goods locations. In terms of support for that cash bail request, I would note, looks like the defendant recently got a similar cash bail out of Kenosha County for a battery in case 25 CM 1086. This is also an Act 3 eligible offense. Looks like he has a bench warrant issued out of Dane County from December 17th of 2024. Looks like he has prior convictions under the Act 3 analysis for that battery that I mentioned before. That's a recent conviction from September of this year. Also reckless child abuse from 2017, battery from 2013, strangulation and suffocation from 2010, and attempted or aggravated battery and first degree reckless endangerment of safety from 1997. Given those factors, the state believes the cash bail is warranted.
Right. Attorney Rakestraw.
Your Honor, I'm gonna ask for a signature bond in this matter. One, due to, it's my understanding that for this bench warrant that Attorney Davies mentioned, Mr. Allen turned himself in to deal with that. And also he has his, in terms of, he hasn't had any sort of child related charges for almost 8 years now, or sorry, for 9 years now. And taking into account the allegations in this one, Your Honor, I am not in any way trying to minimize accusations of child abuse or anything of that nature. However, what's listed in this complaint is, I would say, on the very minimal side of that equation. I think there's probably going to be a fair argument for reasonable parental discipline, depending on what happens in court. But I do not believe these allegations warrant a cash bond situation. Mr. Allen will show up to court. I do not have an objection to the no contact, but I do not believe the allegations in this complaint warrant cash bail, Your Honor.
All right, any response from the state?
No, Your Honor.
Well, Mr. Allen has a long history of convictions for violence. You know, maybe some parts of the country or just some people, smacking a kid in the face is reasonable discipline of a child. I can remember seeing my sister get smacked in the face by my mom, and she would never do that. It really stands out. I agree with the state, given the history of the convictions. I think $1,000 is reasonable. You know, I don't find guilt or innocence in hearings like this. I understand these are just allegations. I understand it could be viewed as just a smack in the face. But I can kind of understand why the state would want to charge a case like this, especially given your history, sir. I'll order that you have no contact with JAB, and I'll also order that you not employ any physical discipline against any child. I won't order the ban from Dick's Sporting Goods. I don't think there's any connection between the offense and that ban. I will enter a not guilty plea as to count 2. As to count 1, that's felony. Will the time limits for the prelim be kept or waived?
Kept.
Okay, we'll keep the time limits in place then, and we are adjourned. Thank you.
Next up is Lynn Burnett. Yeah, that's right, sir. Oh, sweet. Oh, yeah.
You're right, really. You. Stop.
Well, because I'm like, you would never win that trial.
Yeah. Oh, yeah. Yeah.
This is the state of Wisconsin versus Lynn Burnett, 24 CF 2939. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Lynn Burnett appears by attorney William Rakestraw. Mr. Burnett is eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, and from my records, it appears the address on the Coosa Trail is correct.
All right. I'm sorry, you said Mr. Burnett was eligible or is eligible for a
Yes.
public defender? All right.
Yes.
So you have the right to have an attorney represent you, bless you, in a case like this. You're eligible for a public defender. They're gonna work on getting somebody appointed for you. That's a process that could take a few weeks. It could also take a few months. I find probable cause in the complaint. What are the state's recommendations?
The state is going to request $500 cash bail. I will ask for the sole non-monetary condition that the defendant not operate a motor vehicle without a valid driver's license. In terms of support for that cash bail request, I would note the defendant did have an arrest warrant issued for a non-appearance at an initial appearance. It did look like our office was in contact with him about setting up that IA. He still failed to appear. My guess is that's the reason why the warrant was issued. There's also the nature of the offense. Hit and runs obviously are a crime with a certain level of non-accountability that makes the state concerned about an appearance in court. That coupled with what is described in my notes as sort of fleeing behavior. I guess that kind of ties into the hit and run and the nature of that type of offense. It all makes the state concerned about potential future appearance at court, and some small amount of cash bail is necessary to assure that appearance.
Attorney Rakestraw?
Yes, Your Honor. In regards to Mr. Burnett's prior failure to appear, I understand the state saying that they spoke to Mr. Burnett about this. It appears the complaint was filed on December 11th. The failure to appear was on December 12th of 2024. It doesn't appear as if there was a lot of time given for Mr. Burnett to make an appearance. If there was contact, I do not see that in CCAP. He thought this, he wasn't aware this had gone beyond that. He thought it was a ticket or whatnot. But he is here, Your Honor. He has not have any criminal record since 2006. So based off of that, he's lived in Dane County for over 20 years. He's raised his children here. Your Honor, I believe a signature bond is appropriate here, given those details. And it's mine. And he turned himself in, Your Honor.
Okay. It looks like that was in Columbia County. Is that correct?
Yes.
Okay. Any response from the state?
No, Your Honor.
From my review of the record, it looks like Attorney Rakestraw's recitation is correct. There's a complaint filed December 11th. There's an initial appearance to be held December 12th, 2024. And then there was an arrest warrant issued that same day. Kind of confusingly, because the court record indicates that a warrant and copy of complaint given to the sheriff's office to attempt to serve. So perhaps the DA's office had spoken with Mr. Burnett. Perhaps something else happened. I'm not quite sure. I think you turning yourself in gives me confidence that a signature bond is appropriate. I'll also order that you not operate a motor vehicle without a valid license. In addition to that, there's two standard conditions of bail. I'll highlight two of them. Follow the law and show up to court when court is scheduled. So make sure you know when court is and show up for court when it's time for court, okay? Your Nakusa Trail address is still a good mailing address? Is there an apartment number? Okay, so we'll get that updated, and let me just check. 44006?
Correct.
Okay, we'll get that apartment number added. So hopefully you'll get mail at that system. All right. I believe, let's see. These are felony charges. Will the time limits for the prelim be kept or waived?
We'll waive them.
Okay, we'll waive the time limits for the preliminary hearing then. And with that, we are adjourned. Thank you.
Next up is Cody Lovejoy.
This is the state of Wisconsin versus Cody Lovejoy, 26 CF 17. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Cody Lovejoy appears by Attorney William Rakestraw. It is my understanding Mr. Lovejoy does not want public defender representation outside of this initial appearance. As such, if he does want us to evaluate him later, he will need to reach out to our office. We are in receipt of the criminal complaint, waive the form of reading.
All right. So you have the right to have an attorney represent you in a case like this. I heard Attorney Rakestraw say you don't want a public defender moving forward. You may still want to complete the evaluation just to see if you are eligible. If you're not eligible, then you can take that finding to the clerk of courts to see if the county will pay for some of the costs for representation, okay? So you have that information if you change your mind. And I'm sorry, Attorney Rakestraw, did you say the address on Prairie Road is a good mailing? It is?
Yes.
Is there an apartment number?
It's a house.
It's a house, okay. We'll keep that address in our system then. I find probable cause in the complaint. What are the state's recommendations?
The state is recommending $1,000 cash bail. I will ask for non-monetary conditions that the defendant first not operate a motor vehicle, second that he not possess or consume any alcohol. I will note the behavior here. This was an extended pursuit, about 2 miles, 8 minutes. Or no, 2 miles, approximately 2 minutes of the defendant driving at 120 miles an hour. That's an extreme speed. It took 8 minutes after the pursuit for law enforcement to find the defendant at his residence. There is an ongoing OWI investigation with blood pending. Given the fleeing behavior, given the pending OWI, I do think that some amount of cash bail is appropriate, and I'd ask for $1,000.
All right, Attorney Rakestraw.
Yes, Your Honor. Mr. Lovejoy has a very minimal criminal record. This appears to be the first charge he's had in 13 years. All his prior charges were low-level traffic offenses. I understand the seriousness of this. However, Mr. Lovejoy does have strong ties to the community. He's lived here his entire life. He has 2 children who live with him. He's employed at Badger City Auto, where he's worked for roughly 4 years. Your Honor, I understand the serious allegations here. Obviously, this is not the kind of behavior that we would like to see from individuals. But I would like to ask for a signature bond, but I don't expect that to happen. So I would ask for cash bail in the amount of $500, as Mr. Lovejoy does apparently still come from limited means. I believe with his lack of or minimal criminal record and very dated criminal record, even with the seriousness of the allegations, I believe $500 is enough to instill in him the importance that he needs to show up to court. And from what I'm seeing, he made his appearances 13 years ago when he was in trouble, Your Honor.
Very good. Any response to the state?
No, Your Honor.
Okay. We're going to order $500 cash with the condition that you're not operate a motor vehicle and that you're not consume or possess any alcohol. I believe that's appropriate. Flee eluding behavior, especially at those speeds, is quite dangerous. So I think that makes cash appropriate. But I think $500, the opportunity to show up for court, bail out at a lesser amount, hopefully, makes sense to me. This is a felony. Will the time limits for the preliminary hearing be kept or waived?
Then we'll waive one.
Okay, we'll waive the time limits then for the prelim. And with that, we are adjourned. Thank you.
Next up is William Bradley. It was just past us. Why not? But otherwise, we need to come. Okay, thank you. Next time, right? We are thinking about it.
This is the state of Wisconsin versus William Rival, 26 CM 23. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
William Rival appears by attorney William Rakestraw. Mr. Rival is eligible for public defender representation. We are received the criminal complaint, waive the formal reading, enter pleas of not guilty to the misdemeanors. And based off of my records, his current address is 1819 Aberg Avenue, Madison, Wisconsin, 53704. All right.
So you have the right to have an attorney represent you in a hearing like this. You're eligible for a public defender. They'll work on getting somebody appointed for you. Hopefully they can do that within a few weeks, but sometimes it's a process that can take a few months. I find probable cause in the complaint. What are the state's recommendations?
The state is recommending a signature bond. I will ask for non-monetary conditions that the defendant first have no contact with Hope B, and that is B as in boy, that the defendant not possess or consume any alcohol, and that he be banned from the Echo Hotel that's located on the 4700 block of East Park Boulevard in Madison.
Wait a second. And then don't go back.
Attorney Rakestraw.
No objections to any of those, Your Honor.
All right. So I'll order a signature bond with the conditions that you have no contact with Hope B, that you not consume or possess any alcohol, and that you're banned from the Echo Hotel on East Park Street in Madison. I'll enter not guilty pleas on your behalf, and we are adjourned. Thank you.
This way. Next up is Luke Gary.
This is the state of Wisconsin versus Luke Gary, 26 CM 26. Can I have appearances, please?
Cameron Davies for the state of Wisconsin.
Luke Gary appears by attorney William Rakestraw. Mr. Gary is eligible for public defender representation. We are received a criminal complaint, waive the formal reading, and are pleased of not guilty to the misdemeanors. And based off my records, the address on South Main Street is the correct address.
We said, Mr. Gary is eligible for a public defender.
Yes.
So you have the right to have an attorney represent you in a case like this. You're eligible for a public defender. They're going to work on trying to get somebody appointed for you. That's a process that can take a few weeks. Sometimes it can take a few months, okay?
Sir.
I find probable cause in the complaint. What are the state's recommendations?
The state is recommending a signature bond. Before giving non-monetary conditions, I would read a note given to us by the victim relaying her wishes. She says that she wishes for no contact except via third party and only related to needs associated with separation, household, and family affairs. This would be Alice G. The state would be requesting no contact, non-monetary conditions of no contact with Alice G. And no contact with Desiree O. Desiree is spelled Desiree. State would also request that the defendant not possess or consume any alcohol.
So the state's asking for no contact without the carve out for the third party.
I'll leave the carve out to the court. I don't believe the charging attorney knew of the victim's wishes when he made that recommendation. I don't frankly know enough to make a decision one way or another.
So can you tell me what the carve out is again?
Yes, her wordage was no contact except via third party and only related to needs associated with separation / household / family affairs.
Right. And Attorney Rakestraw.
You asked for a signature bond?
Yes.
Okay. Your Honor, no objection to the signature bond or any non-monetary conditions. My understanding, Mr. Gary and the alleged victim in this matter have already worked out a separation agreement. His stuff has been moved to his brother's house. He's going to be staying with his brother. He just doesn't know his brother's address off the top of his head. So I don't believe there's going to be any issues with the no contact. Based off of the criminal record, his anything he has is fairly dated. So I think a signature bond is appropriate.
All right. So please make sure to update your address with the court system because that's where we send our notices for the mail, okay? You can also check on CCAP or if you have a phone, sign up for text message notifications as well. So you can get your notices for court that way, all right? Any response from the state?
No, Your Honor.
Okay, I'm going to order a signature bond. The conditions that you have no contact with Alice G. Except through a third party for the purposes of separation. Strike that. I'm just gonna order the no contact with Alice G and Desiree O. I think the carve out is too vague to really be enforceable. And also it sounds like the separation has already occurred, so that may be a moot issue there. I'll also order that you not consume or possess any alcohol. Yes, sir.
Sorry, Your Honor. I believe part of the issue is with the no contact. I believe what they're trying to carve out is Mr. Gary and the alleged victim run a business together. She's the accountant, so I believe she's asking for some sort of contact so they can still run their business in some way through third party contact.
Okay. And does the state have a perspective on that?
No, not at this time.
Because the carve out wouldn't include a business the way the victim worded it. It would just be household needs, separation, or family affairs.
I believe as long as, I mean, if he can, from my understanding, my client's like, as long as he can have indirect contact in regards to the business, that he's fine with that. He's not trying to reach out to her for any other purposes.
Indirect contact about indirect contact with the business or contact with Alice G through the business.
Because, so, does she work out of the? So she works at the restaurant, she's right out to business finance on her. So I would just, relay acquisition. Or to put into books. Got it.
Okay, so your Honor, the situation is, Mr. Gary owns a restaurant. She's the accountant for the restaurant. All the business files for the restaurant are on her computer. He would just be sending messages regarding the books for the restaurant to her so that she can keep up with the books.
Okay.
That's the only contact he's asking for. So,
and that clarifies things for me. Thank you. So I'll order no contact with Alice G except through a third party for purposes of running the business. I will enter not guilty pleas on your behalf. Bail conditions are flexible. That can mean they can be escalated, right? So it could just be a straight no contact, be a broader no contact with Alice G. It could include a significant amount of cash where you wouldn't be able to be released, okay? So please make sure you're following these conditions. Violating the conditions is a violation of the law itself, and the state could charge a bail jumping charge, okay? So if you have any questions about these conditions, please reach out to an attorney. You can ask your attorney now, or you can ask Attorney Rakestraw now. But it's going to be very important that you follow those conditions, okay?
Yes.
And I believe that's all I can do for the parties today, so we are adjourned. Thank you.
Good luck.
Next up is Brian Peterson for appointment.
So am I good?
I think you're good.
All right.
Did everybody have a good day?
Thank
You too.
Thank you for your work.
It was long, but it's fine. Yeah. That's Mike. Yep, thank you. Peterson?
This is Dane County versus Brian Peterson, 26 FO 21. Can I have appearances, please?
Cameron Davies for the people of Dane County. The defendant appears in person, in custody, without counsel.
And are you Mr. Peterson?
Huh?
Are you Mr. Peterson?
Yes.
Good afternoon.
Good afternoon.
The state has decided to charge your case as an ordinance violation instead of as a criminal violation. Specifically, they've charged you with a county disorderly conduct charge. I expect there will be an offer to resolve your case today. What that means is whether you decide to resolve today or not, you'll be unconditionally released from custody for this case. However, if you have other cases, they could affect your release. And is there an offer to resolve today?
The county would resolve for court costs.
So you have an absolute right to plead not guilty, and we can set this case for further proceedings. Otherwise, you can enter a no contest or guilty plea. You'd be fined $114.50. Payment of that amount could be arranged through the clerk of courts, and you'd have 66 days to pay that amount. you like to resolve today for the $114.50?
No, I don't have, no.
Okay, then I'll enter a not guilty plea on your behalf. In regards to the trial would be to a judge unless the court receives within 10 days of today's hearing written notice of a request for a jury trial and a $36 non-refundable fee. That would be to a 6-person jury. There's no right to an attorney in a case like this, but if you wanted to hire one, you could hire one to represent you. Assuming nothing new comes in, I'm guessing the state will likely keep its offer open until the pretrial conference, which will be the next step in this case. And with that, we are adjourned. Thank you.
Right, this way, Mr. Pinches. That's everyone.